I think you've got to go back to what this report is about and what the findings were. This is a report where Sir Peter Openshaw decided that the Chief Minister had acted in a grossly improper way, sought to attempt to interfere in a criminal investigation and that the Chief Minister was unable to properly navigate the conflicts of interest with the senior partner of Hassans. He recommended that there should be a law drafted to deal with conflicts of interest, and he said that it should be perhaps modelled on the Canadian model. But do we really have to get to the stage where the government now instructs someone who has a long-standing relationship with the government and with Hassans to draft that law? Do people really think that is the reasonable and proper thing to do? Have the government learnt anything from what Sir Peter Openshaw himself talks about the importance of appearances?
Well, Daniel Greenberg is an independent lawyer who serves as Commissioner for Standards in the House of Commons, and you yourself said he's an unimpeachable professional. But by saying he should not be drafting this bill, aren't you suggesting otherwise?
We're saying that it's important to look at the big picture here. And the big picture here is that underlying the recommendations of Sir Peter Openshaw and his findings, he is expressing real concerns about how conflicts of interest are handled and the importance of appearances. And having come from a report where the navigation of the conflicts of interest are between the government and Hassans, do you ask someone who has a long-standing relationship with the government and Hassans to draft that particular law? Daniel Greenberg is not drafting this law as Commissioner for Standards. He's an independent lawyer in private practice obtaining payment for these services. The point is not about the individual. It's about the fact that the individual has a relationship, a professional relationship with Hassans and the government, and in the context of the fact that the McGrail inquiry was all about the inability of navigation of conflicts between Hassans and the Chief Minister. Those were some of the important findings. We think it's not the right thing to do in principle to get a lawyer with those existing relationships to draft the law, because there are, after all, thousands of lawyers out there who could be drafting this law. I mean, are we really supposed to believe that it's only possible that this particular person draft the law? There are hundreds of other lawyers out there that could be drafting this particular law.
Well, Sir Peter Openshaw's report also highlighted the importance of safeguards that needed to be in place, and the government has consulted with the public and the private sector representatives. So this isn't just a drafting between the government and a lawyer it works closely with.
Look, we are going to issue our reaction on the substance of the law on a separate occasion, and we're going to deal with that. And we have some serious concerns about the substance of the law. But today is not a reaction that we're giving on the substance of the law, about the extent of consultation, about whether it's engaged properly or not. We're dealing with the principle that having come out of a report where the most serious findings about the attempts and the grossly improper conduct of the Chief Minister are about the relationship with a particular law firm, you do not, as a matter of principle, no one reasonable out there thinks it is the right thing to do to get someone with precisely a long-standing relationship with the government and Hassans to draft the law.